As we proceed to fifth vertical column of the first schedule of the Criminal Procedure Code, again we come across classification of offences under two different heads. Some offences are shown as bailable offences, whereas some offences are shown as non-bailable offences. Now, whether the offence is bailable or non-bailable, if you read the definition as it is dealt by section 2A, you come to know bailable offence is that which is shown as bailable as per the first schedule of the Criminal Procedure Code. But this has got only reference to the first schedule, and hence there is no definition of the offence. Hence now, in order to note details regarding bailable and non-bailable offences, as you understand the definition, you read the definition. Along with the definition, this is a time for us to refer to right from section 436 up to section 450 of the Criminal Procedure Code, and the heading of the chapter is provisions regarding bail and bonds. What is bail? Bail presupposes arrest. And what is arrest? Arrest is an encroachment with respect to personal liberty guaranteed by Article 21 of the Constitution of India, which says no person shall be deprived of his life or personal liberty except according to the procedure established by law. There can be arrest with warrant, for which I had a reference in the past, with which we shall be dealing right from section 70 up to section 81, arrest with warrant. But there can be arrest without warrant also. For that we will refer to right from section 41 up to section 60 of the Criminal Procedure Code during course of our lecture series, no doubt about it. But then, as you read this, what is bail? Bail is setting person free from legal custody subject to certain conditions which are required to be fulfilled, and hence bail comes into provision regarding bail. They come into operation only when the person is arrested. What do you mean by arrest? All these details with which we shall be dealing when we will start discussing right from section 41 up to section 60 of the Criminal Procedure Code. Now, what do you mean by bailable offence and what do you mean by non-bailable offence is the next question. If you refer to section 436 of the Criminal Procedure Code, you will come to know if the person is arrested on the accusation of an offence of which nature is bailable, he can claim bail as a matter of right. So, bailable offence is that offence in which case person can claim bail as a matter of right, whereas non-bailable offence is that offence where person cannot claim bail as a matter of right, but that is entirely at the discretion of the court of law as far as section 437 of the Criminal Procedure Code is concerned. Now, is it that if the person is accused of a non-bailable offence, he is not released on bail? No, he is released. He may be released on bail, but there are certain situations which are enumerated. If the person is accused of arrested, and if he is accused of any one of those offences, there is no discretion which vests in a court of law to release such a person on bail, to which there are certain exceptions for which we have to read section 437 in detail, with which we shall be dealing when we deal with this particular chapter, namely provision regarding bail and bonds. One more aspect, passing reference I can make is, generally we come across one term. What do you mean by anticipatory bail? If you read Criminal Procedure Code, you don't come across this term anywhere, namely anticipatory bail. But then the provision as we have as far as section 438 of the Criminal Procedure Code deals with what do you mean by anticipatory bail. We shall work out details during course of our lecture. And then rest of the provisions, there can be bail with bond, there can be bail without bond, there can be bail on cash security, there can be bail on personal bond. All these details, there can be rejection of surety, there can be cancellation of surety, asking a person to give fresh surety. All these details with which we shall be dealing as far as the rest of the sections, as far as this chapter is concerned, right from section 436 up to section 450 of the Criminal Procedure Code. Now the time again for me to draw your attention, though we are dealing with fifth vertical column of the first schedule of the Criminal Procedure Code, importance of the second schedule. When you read, try to understand provision regarding bail and bonds. This is the time for me to draw your attention. During course of time I will again refer to it, but if it is not referred by me, you should not forget. And what is that? The time for you to refer to second schedule of the Criminal Procedure Code. And when you deal with the second schedule of the Criminal Procedure Code, do read to understand right from section 436 up to section 450, to be read with fifth vertical column of the first schedule of the Criminal Procedure Code, to be read with the definition of bail. Do read form number 44A to form number 56 in order to have clarity regarding understanding of the topic with which we are dealing. Again, this will make very clear the importance of the second schedule of the Criminal Procedure Code. So this is as far as fifth vertical column of the first schedule of the Criminal Procedure Code. As I had made mention that what about the offences? This is with respect to what? Offences as far as Indian Penal Code is concerned, with which the person is accused. Right from section 109, the first section with which a person can be charged and person can be accused of, or person can be convicted as per section 109, and the last section is section 511. What about offences which are defined by other enactments? Same provision, same principle as we have dealt when we dealt with the provisions regarding cognizable and non-cognizable offences. Now, in order to know whether the offence is bailable or non-bailable, you have to find out whether there is express provision as far as that statute is concerned. If it is so, you have to go by the statute. If the statute is silent, if it doesn't make mention as to whether the offence is bailable or non-bailable, then you have to remember one figure, and the figure is 3. If the offence is such for which punishment is less than 3 years, such offences are bailable offences, and if the offence is such for which punishment is 3 years or more than 3 years, such offences for all practical purposes are non-bailable offences, and hence the importance of rest of the part of which I hope by this time you must have taken notice. With this now, this is the time for me to proceed to the last vertical column in order to finish with the importance as far as the first schedule of the Criminal Procedure Code is concerned. Before I proceed to the sixth, namely the last vertical column, the time for me to remind you, whenever I refer to some provisions of the Criminal Procedure Code, do have ready reference, and for the purpose of ready reference, do have Bare Act with you. Do read that immediately, or whenever I tell you some chapter, I have made mention of some chapter. So this is the manner, by correlating the chapters, by correlating the sections, it is possible for you to understand Criminal Procedure Code as a whole. And that is the approach, that is the reason. Before I have started discussing of the provisions as far as rest of the chapters of the Criminal Procedure Code is concerned, as and when I am trying to introduce you to entire Criminal Procedure Code, of which you have to take note, we shall discuss last vertical column as far as the next part of our series of lecture is concerned.